Ladies and gentlemen, AOC is very upset at the Supreme Court of Virginia.
It's one thing to talk about the maps. It's another thing that this court went in and overturned the will of 3 million Virginians.
I'm Rich Lowry of National Review, and of course that was AOC. She was taking a reporter's question about this decision of the Virginia Supreme Court to invalidate an effort by Virginia Democrats to gerrymander Virginia like, to quote Donald Trump, it's never been gerrymandered before. They wanted to go from a 6-5 Democratic advantage in the House of Representatives to a 10-1 advantage. And the Supreme Court said, you know what? You made a huge process error here in the process of passing this referendum. So even though it passed a couple of weeks ago, it is now invalid. And AOC made this argument. We've heard it a lot from other Democrats. That's so dishonest. That is so incredibly cynical that it's worth dwelling on and getting to the ground truth on. More from AOC.
They can say whatever they want to say about their reservations on the ballot initiative, but they explicitly chose to issue this ruling after the election happened. They had all the time in the world to issue an opinion or an injunction before allowing this election to happen.
Sounds terrible, right? How could this happen? The voters of Virginia have spoken, 3 million of them. 3 million voted, not all of them voted for it. In fact, it was a very narrow outcome, although Democrats prevailed. And the Supreme Court of Virginia comes in and out of nowhere strikes it down. How could they do that? They should have stopped it beforehand, before we go through this whole process and get the voters speaking, before swooping in at the end like this in an illegitimate and undemocratic manner. Now, this is so preposterous. I'm going to walk through why. It can be a little detailed here, a little complicated. Bear with me. I know you will. You always do. So Virginia back in 2020 passed a constitutional amendment to give districting to an independent commission. This was quite a popular measure. It goes to the voters, passes with, I think, something like 66% of the vote. So when Virginia Democrats decide they want to get involved in the so-called mid-decade redistricting fight, they want to respond to what Texas is doing, they got to amend the Constitution to do it, because they got to go back and take the districting away from that independent commission and take control of it themselves. Now, the process for amending the Constitution in Virginia is quite complicated, appropriately so. It shouldn't be easy to amend any constitution. It's not easy to amend the federal Constitution. But what the rules say is, to go about this, you need the General Assembly to pass proposed language for a constitutional amendment, and then you need an intervening election. So they pass the language, and then the election is a way for voters to render an initial verdict on what the General Assembly has done. Maybe it's a proposed constitutional amendment that everyone hates, so everyone wants to vote against everyone who voted for it. Or maybe it's a constitutional amendment that's very popular, so people want to vote against the people who voted against the proposed language. Whatever it is, this is an element of democratic accountability. Then after you have that election, you have a new General Assembly, some members win, some lose, etc. They have to pass exactly the same language for the proposed constitutional amendment. Then it goes to the voters. Now, what actually happened in reality in this process is Democrats short-circuited it, because Texas Republicans do their thing. Virginia Democrats decide they're going to respond, but it's late in the year. So when the General Assembly passes their proposed constitutional amendment to take this power away from the independent commission and let Democrats write the lines, draw the lines that they want to draw, the election is already happening in Virginia last year. There's already been a ton of early voting when this proposed constitutional amendment passes the assembly. So what you've done is you've denied those voters their opportunity to render a verdict on what you've done. Now the election happens, then there's a new General Assembly. They pass the same proposed language. It goes to voters, and as we're just discussing, it narrowly passes a couple weeks ago, and then the Supreme Court comes in and says, you know what, you short-circuited it, it's invalid, we're throwing this whole thing out. And that's what AOC is objecting to and saying the court could have stopped it earlier, and since it didn't stop it, wow, why is it coming in now after people have voted? But the thing is, Democrats were the one at the time. The Commonwealth of Virginia, controlled by Democrats, was telling the court, do not stop this process. You have to let it go forward. All the president says, you let it go forward. And then afterwards, if you want to, you can render a verdict. Now, Democrats were arguing this, obviously, because they wanted to create a fact on the ground. They wanted to have the actual vote happen and dare the court to actually go and overturn it. Because if the court did, then Democrats would viciously attack it for coming in after the fact and overturning the result. Exactly what AOC was doing right there. So this is incredibly cynical. Now, if you don't believe me that this is what Democrats and what the Commonwealth of Virginia were arguing beforehand, let this process go through, even if it might be defective, even if you think there might be something invalid or improper about it. It is right there in the Supreme Court's decision. It's not hard to find. It is there in black and white. Let's take a look. So here it is. Again, this is the decision striking down the referendum. And it says it's fair to ask whether we could have or should have reviewed the constitutionality of the proposed amendment prior to it being presented to the voters, but is not a question the Commonwealth should ask. Throughout this litigation, the Commonwealth, again, the Democrats who run the Commonwealth of Virginia, has insisted that we cannot lawfully decide this case prior to the referendum. In its motion for a stay in this case, the Commonwealth argued that longstanding Virginia precedent, Scott versus James, was, quote, virtually indistinguishable, unquote, from this case, and that it clearly held that, quote, courts cannot interfere to stop any of the proceedings while this permanent law is in the process of being made, close quote. Then the court preempts the criticism we're hearing from the likes of AOC, having successfully insisted that we postpone judicial review of the constitutional amendment until after the election process. It might be tempting for the Commonwealth to think that the final vote implicitly stacks the deck in its favor, perhaps enough so that the exercise of any judicial review could be viewed as an ultra-vires effort to overturn the will of the people. If this supposition were true, the court adds, then judicial review of allegedly unconstitutional procedures used to adopt a constitutional amendment would not exist in the Commonwealth of Virginia. So what the court is saying there at the end is if there's an invalid constitutional process and you can't stop it while it's ongoing, you can't stop it before it gets to the voters because that violates court precedent. And on the other end, you're saying now you can't stop it after it's happened because that would be violating the will of the voters. Then there's this escape hatch. There's like this double bind where you can't stop an invalid constitutional process. The court can't enforce the rules. And this is a way to violate the Constitution in the course of amending the Constitution. This came up in the oral arguments.
The proposed constitutional amendment has been ratified and is now part of the Virginia Constitution. The Circuit Court attempted to interfere with that democratic process by halting it. This court properly put a stop to that. The challengers here now try to overturn the results of that democratic process. This court should not countenance that either.
I don't understand that as a legal argument, given that you asked us to invoke our ironically enough named Scott decision from over 100 years ago that specifically says you don't deal with any potential procedural irregularities before the people have voted. So saying that the people have voted yes after having said you don't even look as to whether there's a procedural irregularity and after it's voted doesn't add anything to the equation, does it?
No, and to be perfectly clear, we're not arguing that this court lacks jurisdiction to review whether the constitutional requirements of Article 12 have been complied with. It does. Instead, I'm saying that on the merits, this court should not accept the challenger's arguments.
But the fact that there's a yes vote doesn't tell us anything about those merits.
No, it does not.
So that was a Democratic lawyer saying it was correct not to stop the process beforehand, and then admitting the fact that the referendum passed doesn't mean that it's necessarily valid and the court can't review it. But that's exactly the argument Democrats like AOC are making now. And it's not just AOC. Here was Tim Kaine after the decision came down. If the Virginia Supreme Court had legitimate concerns about this referendum, the time to stop it would have been before 3 million Virginians cast their ballots, but the court let the process move forward, and Virginia sent a message loud and clear. Again, Democrats argued against stopping the process beforehand. It's impossible to have any sympathy for the Democrats here. This would have been one of the worst gerrymanders in the country, if not the very worst. They would have taken a state where about 47% of people are Republican, a purplish state, and giving Republicans only one congressional seat, and they wanted to violate the Constitution in the course of amending the Constitution to do this, but they've worked themselves into an insane lather over this. Here is a tweet from Democratic super lawyer Mark Elias, basically playing with the idea of eliminating the government in Virginia over this. Here he is quoting part of the Virginia Constitution. Whenever any government shall be found inadequate or contrary to these purposes, a majority of the community hath an indubitable, inalienable, and indefeasible right to reform, alter, or abolish it in such manner as it shall be judged most conducive to the public weal. That's pretty radical. We basically need revolution in Virginia if Democrats don't get their partisan gerrymander. Here, by the way, is more from AOC.
When we talk about our system of checks and balances, in my opinion, it is the power of the American people that should be the ultimate check on all three branches of government. Elected officials, us as members of Congress, we have to respond to the American people in election. The president, of course, has to respond to elections. And so I think that the Supreme Court, when it comes to a check on their power, I think that the court's ability to overturn an election that was clear in its result should be something that should be called into question.
If you take what AOC is saying seriously there, she's basically saying we should be governed by plebiscite. That's not how it works. We live in a constitutional republic. We have state-level constitutions and a federal constitution that create guardrails around certain important rights and set out the fundamental processes for how we go about governing ourselves. Now, Virginia Democrats can amend the Virginia Constitution, and they can, after they do that, they can gerrymander however they like. They just have to do it in keeping with the rules set out in the Virginia Constitution. And that apparently was too much to ask. And given that they failed at that basic test, it doesn't matter whether the referendum passed or not. It was invalid, and it was correct of the Virginia Supreme Court to strike it down no matter what AOC says now. I'm Rich Lowry, over and out.